good beginning yesterday afternoon and yesterday evening. We are now going to talk about what we originally had in mind as the first session, but our schedule was somewhat reorganized due to the exercise of presidential power. One of our speakers had a schedule conflict, and I guess the question was, does our speaker go to Washington or do we get the president to come here? We're going to be talking this morning about the appointments process. For many years it's been apparent that whatever the scope of presidential power, the president is not going to do it alone. The president needs people who will be able to carry out the president's policies in various ways. We also know that the appointments process involves both the president and at the higher levels of officers of the United States, involves as well the Senate. And we're going to have today two papers on the appointments process and then three comments. The first paper is by Jeffrey Tulis, who's a professor of government at the University of Texas, and someone who has written some very well-regarded work on the presidency, most notably, I guess, the rhetorical presidency. Will be followed by our dean, Michael Gerhardt, who has written on the federal impeachment process and is now working on a book on the appointments process. And we'll then follow with three comments, one from Yvette Barksdale, who's written on presidential leadership. She's at John Marshall Law School. Elena Kagan, who is on leave at this point from the University of Chicago, having held a position in the White House Counsel's office and now another position in the White House. And we'll conclude with Ron Kahn from Oberlin College, who has written on the Supreme Court and constitutional theory, and will try to set the rest of us straight, I hope, at the end. Well, let's get started, and let me turn it over to Jeff Tulis.
Thanks. I'm really happy to be here. It turns out that Dean Gerhardt and I are going to do something unusual for a conference, which is confer and conference, and try to extend something of the discussion from yesterday. So I will say a few words about the paper, which is in the packet, and which the commentators are going to comment on. But rather than just restate the argument of the paper, though I'll try at some point to briefly remind you of what it's about, I want to situate that in the larger discussion of which it's a part, and that turns out to be the same basic agenda for discussion that Ted Lowy set out at the beginning of the conference. And if I were to be asked to vote in a poll, Lowy would certainly get my vote again for this decade. And the reason for that is he really thinks about big and important things and comes up with fairly profound ways to rethink our polity. And what's characteristic of Lowy's way of thinking, which is not characteristic of the discipline of political science as a whole or of other disciplines that study politics, is that he is neither interested in explanation as conventionally understood by social science, nor in evaluation as conventionally understood by normative theory and philosophers. He's interested in what could be called a diagnostic exercise. And it's that kind of exercise that I'm also interested in. The chapter that is in the packet is from a book that I'm writing called The Politics of Deference. And I'd like to just say what that's all about and why this issue of senatorial deference to the president over the nomination and appointment of Supreme Court justices I take to be an example of constitutional abdication and an example of a pathology of our polity, and indeed the very pathology that Ted Lowy mentioned last time. Now, the interesting thing about Lowy, and I wish he was here to hear this, we've been in conferences and before, and I've said this, so it wouldn't be new to him what I'm going to say, and it's actually a kind of weird sort of compliment, but some of you may not interpret it that way. Lowy has never allowed the facts to get in the way of the truth. And so it requires little guys like the rest of us to come around behind him and clean up after him after he talks. And so that's what I'm going to start by doing this morning. The last 2 decades have witnessed an ongoing debate regarding the merits of our national governing institutions. It's sometimes called a governability crisis. This is what Lowy was talking about. The ability of our government to address or let alone solve long-standing social problems has been called into question, and the responsibility of those who are allegedly tasked with the job of addressing societal problems is thought to be non-existent. It's an instance where a debate central to the discourse of American political science today is actually replicated in the public sphere. It has a kind of palpable relevance. And this debate, much of this debate, has centered on the adequacy of separation of powers, which we had an awful lot of, I think, good discussion about yesterday. Now, a view popular in the press has also become a kind of textbook view in political science. That is, it's literally the thesis of many introductory textbooks, and it's in fact the sort of thesis or opening thesis that Ted Lowy mentioned yesterday. And that's that separation of powers was a kind of arrangement suitable for the 19th century, but not now. It's a kind of anachronism. The roots of this critique are in progressive thought at the turn of the century, but it finds articulate voice today in the writings of people like Lowy, Sundquist, Dean Burnham, Donald Robinson, Lloyd Cutler, and others. You could call it a neo-Wilsonian view. And the basic point of the basic character or feature of the neo-Wilsonian view is that separation of powers is interpreted simply as checks and balances. I was surprised yesterday that Lou Fisher didn't jump up and down when Ted Lowy at the beginning of his talk, and at the beginning of the paper that you have in there, says that separation of powers was designed to secure liberty, and it had no connection at all with the securing of any notion of efficiency in government. And Lou wrote many years ago a very important and influential article on the efficiency side of separation of powers. But this view that Lou rebutted is the one that Lowy actually articulated yesterday. And that view, Lowy's view, is a response to yet an earlier view, which also found some voice yesterday, a kind of legalistic view that has resulted in what lawyers sometimes call the separation of powers doctrine, the notion that one can legally demarcate the powers appropriate to each branch and sort of hermetically seal them off one from the other such that one could say a branch is acting appropriately or not. After years of critique of that view, the sort of Lowy-like view, which he aptly quoted Neustadt as first articulating, that we had no separation of powers but rather separate institutions of sharing power, seemed to be in the 1950s and 60s a kind of breath of fresh air to the earlier fairly cramped legalistic understanding. And the idea of this new political view was that there are no powers at all, only power, a single entity like energy, and that institutions are designed to check each other from having too much of it in the service of liberty. Institutions are designed to protect each other to protect themselves from the encroachment of the others. Now, it is this idea that is behind much of the writing today that suggests that our politics is prone to deadlock, stalemate, gridlock, unhealthy conflict between the branches, multiple veto points, on the general proposition that nothing gets done about important matters and that no one is held to blame. Our politics is supposedly inefficient and unaccountable. And the ideal offered is a kind of version of parliamentary critiques of American politics. Now, this critique was intensified, as Lowy also mentioned, by the development of divided government in recent years. the holding of one institution by one party and the other institution by another. I briefly want to chart the response to this understanding, this neo-Wilsonian understanding, a response that Lou has participated in and that I've participated in, and I want to chart it because one of the virtues of Lowy's remarks yesterday is that he, like me now, find serious inadequacies with this response, even though I think it's in many ways a good response. One could call it the Neo-Federalist response to the Neo-Wilsonian critique of American politics. And where I'm going with this is, at the end of the day, Lowy sees the pathology of American politics rooted in the disconnection of political parties from separation of powers. But separation of powers understood in the old progressive sense of checks and balances. And what I'm going to be suggesting is that the pathology that Lowy recognizes is our pathology, but it might be rooted in separation of powers itself, albeit an understanding of separation of powers more interesting and more sophisticated than the one that Lowy charted for you yesterday. So the Neo-Federalists respond to people like Lowy in the following manner. They suggest that recent history seems to reveal a remarkable number of counterexamples to the idea of stalemate. Reagan's tenure as president, the Gingrich Revolution. In general, periods of normal politics are routinely punctuated by bursts of large-scale policy changes, the very sorts of changes the checks and balances view is supposed to frustrate. At the same time, close analyses of parliamentary regimes that are supposedly the great alternative are not seen to in any way approach their idealized versions. Similarly, David Mayhew, a political scientist at Yale, and Mo Fiorina at Harvard have displayed the empirical and normative inadequacies of the divided government part of the textbook view. Mayhew, for example, shows that if you divide American politics since World War II into its unified and divided periods, and there were a number of unified periods in that time, that there were no important differences in the number of major policies or the number of major investigations, the number of major sorts of institutional innovations that were enacted or created in each period. Now, there are several versions of this Neo-Federalist theory, that is, of a new view of separation of powers, and I just want to chart one that I know well, which is my own, but not the whole thing, just a little snippet of it. And the key here is that separation of powers should be understood as an appellation applied to a system in which the separation of powers doctrine, as understood by law professors and lawyers, is but one component. And the separation of powers system was designed to institutionalize three conflicting purposes of liberal constitutionalism, three purposes that are in tension with one another. Security, as in national security, the securing of majority will, or the effectuation of majority will, and the protection of rights, or as the third. Separation of powers is an arrangement designed to make these tensions productive, acknowledging the legitimate claims of each in the construction of public policy. Each of the three major institutions, then, President, Congress, and Court, is an ensemble of structure and powers and attributes, an ensemble of structures, powers, and attributes designed to create different political perspectives and a different set of priorities regarding the construction of public policy. And so any particular public policy, then, will be approached with different considerations in mind, depending which institution you happen to stand in. And the virtues of the virtues brought by energy to our system are going to be represented by the government, by the president. The virtues of deliberation by the Congress, of judgment in its idealized version from the court. And each of these three things themselves will be in the service of the purposes that I mentioned that were in tension. It's sometimes said that these institutions are coordinate and co-equal. That is true only if one understands that they have advantages in a political process at different moments in political time. So a president, for example, has understandably enormous advantages at the outset of political activity, and the Congress has enormous advantages and enormous responsibilities, as it were, in retrospect. This ties in a little bit with what Professor Shane was saying yesterday, that it really is somewhat appropriate for Congress to be somewhat out of the loop at the initiation of certain kinds of executive actions, and it's also appropriate for them to be very much critical and in the loop retrospectively. That coheres well with the particular structural virtues they bring to the separation of powers process. An important conclusion from all of this is that major constitutional disputes only look like deadlock at any single slice in time, but over time there's considerable movement. And I think a great example for that is last year's budget standoff shut down the government business. The day the government was shut down, that was as close to gridlock as that was gridlock, but it was just 8 hours. And a lot of stuff was happening politically before and after that particular 8 hours. Defending turf is defending a perspective from each of these institutions that in general we want to bear on policy. The process is remarkably dynamic, and accountability is accountability in multiple senses. In this picture, constitutional discourse has real significance as the particular partisan motives of the institutional office holders are transformed into the rationalizations of constitutional argument that take on a life of their own. Now, a lot of this should be familiar to you, but I wanted to get it out on the table to make this more simple, but I think important point. The progressive view that we have checks and balances and the Neo-Federalist view that we have a good and complicated separation of power system that is not simply checks and balances, but a kind of complex of attributes that includes a distinction between powers, different kinds of things, that both these views see conflict as pervasive in American politics. The neo-progressive view sees conflict as bad. It's all over the place. It's bad and it's irresponsible. The Neo-Federalist view sees conflict as very, very good and responsible. And one way that you could characterize Lowy's remarks is he's a neo-progressive who actually thinks that conflict is good. And my remarks are designed to advance the proposition that our system really is neo-federalist. Conflict would be good, but we actually don't have as much of it, agreeing with Lowy. We actually don't have the conflict that the separation of powers system supposedly promises and, in the view of critics, supposedly frustrates us. But instead, we have a whole pattern throughout of our governing institutions of abdications of power, of deferences to other institutions, of a virtual refutation of Madison's claims that we could somehow unite the ambition of office holders to the duties of the place, that somehow in exercising their ambition they would stick up for their institutional prerogatives and fight with other institutions. We have a whole series of examples since World War II in which that just simply isn't the case. And I don't want to take the whole time, but the example that you have on the table, I have several examples of this that I'm working on in the book, and some of them people were talking about yesterday. War powers resolution being one, pre-commitments, which Lowy talked to, binding to the mass, that's pre-commitments being another, and the legalization of separation of powers disputes, which some people talked about whether the court should be involved. I don't think they should, but that process is another form of deference. But one of the most visible is the one that is the subject of our panel today. That's the appointment of Supreme Court justices. And basically what I try to show in the paper is that in the 19th century, we had a generally agonistic, contestable political process in which the Senate was involved in the nomination and appointment of Supreme Court justices as fully, as it were, as the President was involved, so that the full range of considerations that a President might bring to bear in the choice of a justice, everything ranging from geography or ethnicity to higher concerns such as particular ideological views or beyond that, judicial philosophy, the whole range was fit subject for debate in the Senate and fit subject for rejection if the Senate disagreed with the President. And indeed, 1 out of every 3 nominees in the 19th century were rejected. And in the 20th century, as you know, we've only had, depending how you count, 6 or 7, nearly 1 out of every 10, or nearly 9 out of every 10 confirmed. Now, some have pointed out that we've had in recent times a spate of controversial nominations, with Bork and Thomas being the most recent and most memorable. And I just want to make a couple of points before turning it over to others. One is that in the 20th century we have, as a whole, considerably less challenge to executive nominations. And two, when there is challenge to nominations, it is on considerably narrower grounds than it was in the 19th century. So, for example, for all but the Bork case, the rejections or even the contested nominations, such as that of Thomas, were only contested on narrow grounds of either gross incompetence, Carswell, or financial or so-called moral improprieties, and those include Hainsworth and Fortas on the financial. They include Thomas on sexual harassment, Douglas Ginsburg on smoking marijuana. A relatively narrow set of considerations as to the fitness of a nominee. And as you know, nominees routinely refuse to answer questions not just about pending cases, but about any opinions that have been written, including some of their own writings. And the Senate tends almost always to defer to those refusals to talk. In the most egregious case, Antonin Scalia refused to answer a question about Marbury versus Madison on the grounds that the issue might come before the court and he was sitting on it. Now, the one clear exception to all of this is one that I think proves the rule, and that's Bork. Bork, the debate was wide-ranging. It covered everything from the lowest to the high, and it serves as a kind of startling counterexample to the entire pattern of the century. I think it's an exception that proves the rule for several reasons. The most important of which is nobody wants to do it again. Everybody regards it as the kind of aberration that is an example of what was wrong rather than right with our politics now. To Bork has become a verb that you don't want applied to you. And in addition, some people are unsatisfied with the character of the debate or the quality of the debate. I wasn't that unsatisfied with it, but I would only urge that part of the reason that elements of it were unsatisfactory, that, for example, senators are incapable of asking their own questions of nominees, is because of the pattern of deference that has led to a kind of political amnesia and political diseducation of our governing class. That's why there's talk now that the Senate Judiciary Committee should actually hire one of you folks, one of you smart law guys, to be their counsel to ask their questions for them. I think that'd be a bad thing. I think they ought to ask their own questions, but that's also a bad thing because they don't know what to say. I don't know if you've ever noticed, they never know how to follow up a question that's been handed to them by one of your students. Well, anyway, that's just a glimpse of what my paper's about and where I think it fits in, and I'll turn it over now to Mike.
Thank you, Jeffrey. I do want to pick up on something that Jeffrey suggested. He and I have had the pleasure of talking about some of the issues we discussed in our papers, and now that Ted's here, I'll say that he and I have also had that similar pleasure. And here's what's left of my paper. What I want to do is address some of the questions that they've raised, and also sort of go a little further to sort of engage, as Jeffrey did, some of the other comments made and perhaps some of the comments that will be made. Let me just sort of state a bias at the outset. I think in looking over the literature on the federal appointments process and looking at how most people write about it, I feel a little bit like Oscar Wilde did when he first saw Niagara Falls, and he said he would have been more impressed had it flowed the other way. I feel somewhat the same about the literature on the federal appointments process because so much of it's about the Senate. And so much of it is about the contest between the president and the Senate over particular nominations, and usually very dramatic ones, and even then usually ones for the Supreme Court. And there is a whole other universe of presidential nominations, contests within the Senate perhaps, or contests or discussions with particular senators about those nominations. And almost all of that is absent from the literature. And I don't pretend to fill that void, but I do think it's an important void to fill. I do want to take a stab at it today, but let me begin by just trying to address a couple of the questions that were asked to me by Jeffrey yesterday. And they're very good questions. The first question really has to do, what is the relevance of history in all of this? And also, there's a question about whether or not it is possible to discern certain models of performance by presidents within the process. Now, I will say that my views on this are relatively simple. To begin with, I think history is obviously relevant, but to a limited extent. And I also think that as you look more closely into history, I think the effort to try and fit presidents into different models ends up breaking down. I'm going to propose here in a moment to try and have it both ways by suggesting that presidents operate more in terms of modes, and one of the real challenges for presidents is to figure out which mode they need to be in order to achieve certain objectives. And when I'm talking about these objectives, I'm talking about both short-term objectives and long-term objectives. I think that's the great challenge. For me, the central question is this. How well does a president use the nomination power to implement his vision, both constitutionally and programmatically, or to secure his place in history? How well does the president use the nomination power, in a sense, to achieve a variety of other objectives? Not just simply to achieve a short-term success, that is to get X into office at this particular moment. That's not insignificant, but that's hardly the whole game. And I want to ask this broader question and then consider the other questions that are implicated by asking this broader question. For example, if you're going to ask this broader question, then you need to ask quite logically, how clear is the president's constitutional and programmatic vision? It's going to be important that if he is setting out to ensure its implementation, that he at least was going to want to articulate it clearly within the administration. I think more importantly, he's going to want to articulate it to the American people. And I think that in the course of measuring what goes on in the appointments process, it's important to figure out what exactly is at stake in this particular nomination for the president, or what's at stake in this particular contest between the president and the Senate over this nomination. Other questions I think we're going to have to answer to try and evaluate presidential performance, or the way presidents try and choose among the modes available to them in maneuvering through this process, are first, how good are the president's management skills? There's a whole array of other powers that are related here, not just the nomination power. And the trick is to employ and manipulate these powers together, to weave them together to achieve a successful outcome. Another critical question, obviously, is how good are the president's negotiation skills? This is oftentimes going to be, and when I say the president, I'm going to explain this in a minute, I don't just mean the president, I mean the president's people, and that is going to be crucial. Because another critical question here is, to whom does the president make important delegations with respect to nominations? Those appointments are remarkably important because they don't typically go through the Senate, but those appointments are going to have an impact with respect to all these other questions. Clearly, another important question is, what's the president's sense of history? What place is he trying to secure for himself within history? This is something that I believe doesn't just mean that a president has to be an activist. I think a president can be someone who's concerned with conserving a particular regime or conserving certain programs, but I think that the importance here is that the president, I think, has got to have a fairly clear idea, but also he's got to be flexible because events sometimes arise, they always do, that require, that change the whole landscape. And I think reacting to that, but also trying to stay on top of it is the great challenge of the presidency. And let me just sort of finish the series of questions, and then I'll get into more particular examples. I also think the other critical question we need to ask is how good a judge of each of the following is the president. The qualifications necessary for the job being filled. Now, this is not irrelevant. The critical thing here is not just whether the person's competent or qualified for this particular job, but the critical question is there going to be a good fit between this person and this particular job? A second question is loyalty. How good a judge is the president of these particular individuals' loyalty, the potential nominees? Third question has to do with these individuals' management abilities. How good a judge is the president of these other people's management abilities? For example, as Neil Devins and I were talking yesterday, one recent study suggests that while President Reagan was extremely good at picking people with a particular constitutional or programmatic vision, he was less successful in picking people who are good managers. That becomes a problem if what you're trying to do is achieve implementation of that vision. Another question is, what is the congruity between the president's views, those of most concern to him, and those of the people he's appointing? Are they on the same page? Think of, although these are not strictly appointments, but for reasons I'll go to in a moment, it's fairly safe to say that when Andrew Jackson had to sit around the table with John Calhoun and Martin Van Buren, those two didn't exactly think alike about most things, in fact, perhaps nothing. But there were a lot of people in the administration that Jackson had, at least at the outset, who were loyal to one or the other. And it's therefore safe to say that those people didn't share much of an ideological vision, at least at the outset. Another thing the president's got to be a good judge of is timing. To be perfectly frank, the timing, we can talk about this further, but there are many problems with the Bork nomination in a sense that might explain why it failed. But one's timing. When you have a Democratic Senate near the end of a presidency that has, I think, had a fairly sort of a particular ideological approach to nominations, you have to expect a pitched battle at that point. And so timing becomes an important factor. The last thing the president has to, I think, be able to do in this circumstance is be able to judge well the relationship, that his relationship, and perhaps even his nominee's relationship with the Senate and the American people. And that obviously is a fairly important concern, but sometimes it doesn't seem to factor much into the analysis. Now, having asked those questions, let me sort of look at a series of examples and by looking at these examples, try and clarify what I consider to be some of the modes in which the presidents need to operate to accomplish their lasting constitutional or programmatic visions of either change or stability. Let me just sort of mention at the outset of this list that there are, the difficulty is that what you'll see as you encounter sort of different presidents involved in the nomination process is they may have to operate, as I said, in different modes. There may be, you can begin in a reform mode, but you may end up in a kind of reconstruction or mode. You may, for example, you may also be involved in what I'll call a unification mode, where you're trying to sort of unite different parts of either your party or even different parts of the country. And so I want to use the following examples to sort of illustrate some of these different, not just modes, but how they affect, how the president's perception of them and ability to maneuver through them factors into the appointments process. Let me begin with the easiest example, and that's Andrew Jackson. Jackson comes into office as someone who's intensely committed to reform. He's also intensely committed to personal vindication. He has an agenda that becomes clearer in time. And he is clearly interested, as time unfolds, in trying to appoint people, trying to nominate people who are going to not just be loyal to him, that becomes increasingly important to him, but also who are going to fight for the implementation of his policies and even for the vindication of his constitutional vision. This is what leads him in his administration in 1831 to nominate Roger Taney, who at that time was Attorney General, to become Secretary of the Treasury. Interestingly enough, the person that Taney replaced William Duane had in fact been originally nominated because he was against the National Bank. But when finally Jackson asked Duane, would you be willing to sort of withdraw the funds that will help weaken the National Bank, Duane at that point sort of raised a legal question saying, I'm not sure I have that power, at which point Jackson, after a couple of attempts to try and persuade him otherwise, just writes him a curt note saying, thanks and have a good trip back home. And at this point, then nominates his great ally, great friend, great lieutenant, Taney. Taney undertakes the task. He certainly is successful in its initial implementation. And along the way, Taney as a symbol of this, becomes a sort of almost a lightning rod insofar as the Senate's concerned, because this is not a popular policy for many senators. Jackson doesn't control the Senate. And in fact, the Senate is in the hands of a lot of people who don't like Jackson. A lot of people who want Jackson's job. So it can't be a terrible surprise, especially given the fact that in his first year, Jackson had 10 contested nominations. It can't be a terrible surprise for Jackson to discover that, in fact, Taney's not going to be able to get through the Senate, and Taney becomes the first rejection of a cabinet nominee in American history. It doesn't necessarily suggest, though, that Jackson was unsuccessful. Jackson was fighting to defeat congressional supremacy. Jackson was in a mode in which he was fighting to wrest the privilege of certain kinds of presidential appointments and control of policy from Congress. So this was just one battle along the way. He immediately responds to that defeat by doing a few things. One of them is he nominates Levi Woodbury to the position, which was a fairly clever thing to do because Woodbury was a senator. And Jackson figured quite rightly that the Senate wouldn't have the stomach to reject Woodbury. And in fact, the Senate doesn't. And then Woodbury does exactly what Jackson had wanted to have done. Meanwhile, Jackson's looking for a way still to vindicate other aspects of his presidency, and this is what leads him twice to nominate Taney to the Supreme Court, first unsuccessfully as an Associate Justice, and then later successfully as Chief Justice. The latter, I should say that Taney gets rejected as Secretary of the Treasury and rejected again as an Associate Justice, largely but not solely because of unhappiness with what he did with respect to the National Bank. Nobody's questioning Taney's ability during this time period. Now, Jackson ultimately succeeds, though, because he also figures out that in order to get a successful nomination, he's going to have to change the Senate. And it's only in the last year of his presidency that, in fact, his party or his critical mass of loyal followers are, in fact, dominate the Senate. And that's the mode that the Senate's in at the time that it approves Taney's nomination as Chief Justice. That's the last year of Jackson's presidency, and then at that point Jackson is enormously happy, and in fact was never necessarily a gracious winner. And he is elated, of course, to watch the Chief Justice Roger Taney swear in the next President of the United States, Martin Van Buren, who Taney rejected twice by the Senate, Van Buren once by the Senate, and this is sort of for Jackson a great moment of vindication. But it's also an illustration, I think, of how the contest, it's not so much winning or losing particular contests that's important, it's I think, a balance of factors, a balance of objectives, both short and long term. It's an effort to try and implement a longer term policy, judging as best one can the abilities of the person you're trying to put in the office, the likely opposition, and what one has to do to get that person in office and make sure that neither the president nor that person are unduly weakened in the process. Which leads me to two other examples, which will probably be counterexamples. One is Calvin Coolidge. Just want to talk about Calvin Coolidge because nobody ever talks about Calvin Coolidge. Now, you'll probably know why in a few minutes. No. As a matter of fact, what I would like to say about Coolidge is that it's important, I think, again, to understand the historical moment that Coolidge occupies when he enters into office. It's in the wake of the Teapot Dome scandal. And initially, his reaction to this, at least insofar as one of his most notable appointments is concerned, is quite astute. Coolidge appoints Harlan Fiske Stone Attorney General. Stone quickly moves to clean up the Justice Department. Now, this is sort of where Coolidge's sort of successes begin to come to an end, because Coolidge also has a different plan. Now, this is Coolidge's vision, and so part of the test here is what's the vision, how is it implemented, is it a vision that, and how does this vision play out within the Senate and beyond? Coolidge is famous, of course, for saying that the business of America is business. So what Coolidge then tries to do is he tries to put into the administration a number of business leaders, and he replaces a large part of the Republican Party leadership with different people from outside the party. Now, this has a disastrous effect for Coolidge. One of the problems that it has for Coolidge is the person he nominates to replace Stone when he nominates Stone to the Supreme Court, Charles Warren, comes from business. Well, in the aftermath of the Teapot Dome scandal, the timing was disastrous. The timing of turning to somebody who's a major leader of business, given the problems that sort of gave rise to the Teapot Dome scandal, was in many respects asking for trouble, and he got it. And so Warren becomes the first person rejected as a cabinet nominee in this century. But beyond that, what Coolidge's mistake comes back to haunt him in a different way. Coolidge is also concerned, as I said, with trying to reform the party, and at the same time change the way change the nature of some government appointments. But having reformed the party leaves wide open the party's choice of a next nominee, because the party feels no loyalty to Coolidge. Coolidge, in fact, helps alienate the party's stalwarts. And in fact, the person that occupies that void is another one of his appointees, his Secretary of Commerce, Herbert Hoover. Hoover swoops in, captures the nomination, becomes the next president. And now I'll talk about Hoover very quickly and briefly. Because here's Hoover's problem. Hoover's problem, interestingly enough, is that he too is in a reform mode. But he's in a reform mode without adequate support in the Senate. He doesn't judge that accurately. Because he fails to learn the lesson of his own success. Hoover comes into office having been brought into office by traditional conservative Republican support. So what is the first thing he does? He says, well, with respect to appointments, I'm not going to take party into account. I'm going to appoint people on the basis of merit, which is it's a noble thing, but it's a thing that's inconsistent with what brought him there. And for Coolidge to do that in such an overt, direct, and early way in his presidency, in a way begins to erode his support. And in fact, it's interesting to note that two presidents in this century have both sort of come into office and early on said, I want to change the way particularly judges are appointed, that merit ought to count and not party affiliation or even ideology. Those two presidents were Herbert Hoover and Jimmy Carter. And they both met the same fate. They both met the fate of even having their own senators from their own party, begin to sort of distance themselves from them and feel very little loyalty. Contrast this with Lincoln. Lincoln comes into office. He understands that his party is it's sort of held together by the thinnest of threads. And Lincoln very craftily sort of uses patronage and merit as a way of bringing in people into government and also trying to keep important constituencies happy. Lincoln's mistake early on, which he learned from, is that this didn't buy him loyalty. It also didn't buy him good managers. And so if you look at the problems that he has early in his administration, they are that there are many people that are not loyal to him, most notably Salmon Chase, and many people that are not good managers. He eventually deals with these problems, but only eventually, which in fact leads me to really just mention, let me just mention the last issue, or the last president I want to talk about, and then I'll finish. And that's just to talk about something that's right now in the news, and to talk about President Clinton and the CIA. As you know, the most recent nominee to head the CIA is the 5th person nominated in 6 years to head the CIA. And the question becomes, what's the significance of that? Well, I think what it reflects is the following. This is something maybe worth talking about later, is I think the appointments process is oftentimes a venue for a tug of war between the President and the Senate for control of certain policy, or the direction of certain policy. And the people that are nominated, even if they're judges, simply become sort of targets or pawns in this game. I think that's a good bit of what's going on with the CIA situation. National security has become a huge area of concern. I mean, it always is, but it's become, in the last 20, 30 years, just a hotbed of confirmation contests. The other thing that I think is important here is this, and this is what I'll sort of end on. One has to sort of think about what is the objective in making a particular nomination. Keep in mind all those questions I just asked. And I think the danger is this, is when you put too much emphasis on one thing and you throw the balance out of whack, then I think you're asking for trouble in the appointments process. So for example, if you're primarily concerned with loyalty, or somebody who will be truly sort of a great lieutenant, or someone you know will be absolutely there to sort of carry out your every whim and desire, you need to be careful that that person doesn't lack some of the other abilities that may be relevant to the position. I don't mean to say anything at all critical about Anthony Lake. What I do mean to suggest is that it shouldn't necessarily be a surprise to find that there are going to be questions raised about the following: his management abilities. It's a big agency. The other thing is questions, of course, about his involvement in a very hot political issue at the time. I'm not suggesting that he's either a bad manager or he was involved in those things, but though you have to expect those questions to arise. And the question, and here's the other thing, if you know those questions are going to arise, you have to have answers. And this all ties back to the original thing which I said, which is what's the vision? What's the programmatic or constitutional vision that one's trying to implement? Because that becomes the basis for defense, the basis for justifying and fighting for a particular nomination. I'd be happy to expand on this further or not, but I appreciate the time, and we'll turn it over to the commentators. Thank you.
All right, hello. I'd like to, I guess, start out by saying that I come to this discussion from, I think, a slightly different kind of perspective. Jonathan Inton, when he did my little introduction, said that I wrote on presidential leadership, but I really would not describe that really as my focus, even though the article that I wrote concerned the presidency. I'm really more focused on this question of how we go about making certain sort of first-order value choices about the direction of the country, and in particular, what I'm concerned about is thinking about whether or not the process for making those kinds of value choices is inclusive, is participatory. And so I come to this discussion with a focus on really thinking about how this process for how the president cooperates with the Senate, and also the role of the president in making appointments and in exercising other parts of the president's responsibilities, on how effective those processes are for sort of translating sort of collective views, collective visions about what our society should be about translating that collective vision into some kind of policy. And so for that reason, I guess I'm a little bit troubled by the focus just upon, is the president winning the battle with the Senate, or is the president just operating effectively in some contexts? Because it seems to me it's very important to think about how effective, how successful this is at translating these collective visions, I guess, into policy. And so I'd like to say that with respect to that, I found really both papers very illuminating, really fascinating, actually. And I really hadn't focused on appointments before, but I think, again, these papers were really terrific for getting me to think about these issues. Starting out with Tulis, who is arguing that the late 20th century Senate really is abdicating, I guess as he said, the constitutional responsibility to, I think if I understand that correctly, to almost really have a completely non-deferential equal partnership role with the president in making appointments. And he's arguing that the current sort of standard of institutionalized deference here is really preventing the appointments of debate from becoming sort of constitutive and deliberative and at least in my view, sort of inclusive, and really is sort of forcing people into this, well, we have to find some way to defeat them on character or on competence, and so that really sort of cheapens the debate. And I think he's arguing that the Senate is constitutionally required to participate in this equal way in the appointments process. And Gerhardt, I guess I didn't see him really as challenging Tulis's deference position directly, but I guess as he's sort of discussed here, really shifting from the question of appointments to the question about how do you evaluate whether a president is or isn't a good president? And I saw his view as really, this idea of vision is really how you do that. And I think in the paper, although I saw him get away from that a little today, he talked about the idea of the president sort of doing constitutional change. And, are you successful at accomplishing this change? And that's really how you go about evaluating whether or not it's a good president or a bad president. And the appointments process is just one tool that the president really uses in his arsenal of weapons, I guess, to really carry this out. But I guess I saw that implicitly as kind of being against Tulis's position of an equal Senate role, because it did seem to me that, okay, if you're going to say the president has got to be accountable for how well he uses appointments to carry out this kind of vision, then you've got to give him a fairly broad ability to make appointments. And so once you do that, then it seems to me you're back to sort of less deference, more deference than Tulis would go for. And I really found both papers, as I said, very thought-provoking. In particular, I think both were concerned about the idea that the process for appointments really isn't about this question of sort of a constitutive question about, what direction do we go in as a nation, whether it's the president's vision or not, but instead is this kind of sort of tabloid kind of gossip kind of thing. But I guess, and at least, as I started out by saying, I am somebody who really is very attracted to that kind of idea that you want to have a more constitutive debate, because again, I'm concerned about translating these sort of collective visions into some kind of a policy. And so both of them, I think to the extent that they're both talking about that, about some idea of making this process of thinking about who's going to be on the court, what is the institutional direction of the court going to be, to the extent they're both talking about making that process, more constitutive and less just about nannies or whatever, that I really am agreeing with them as to that. But I guess I have a problem with, I'm not going to have a problem. I have questions about both of their solutions, whether it's Tulis's kind of no-hold-barred Senate role or Gerhardt's, I think, really kind of an imperial kind of president who's really out there, more or less imperial maybe, out there to find a vision and then carry it out and then be evaluated on how well he or she has done that. And I guess sort of starting out with Tulis, and I had some discussion here about whether I agree with his, number one, I don't want to get into this historical debate. They're debating over whether or not the history is, is it more Senate deference or is it more presidential control, I guess. I'm sorry, more Senate, not deference, more Senate involvement or more presidential control. And I'm not really an historian at all, so I really don't want to get into that. And I was going to kind of talk a little bit about, at least the question of whether or not, Senate deference is or isn't constitutionally required, and Tulis says equal partnership is required, and I think Gerhardt, at least in his paper, said that deference is constitutionally required. I guess at least my view would be, at least at this point, to accept that either position would be constitutionally permissible. And I guess sort of tying in from the question, from the discussion yesterday, I'm one of those people who thinks there's not a whole lot of mandates, at least in terms of structural issues, written into the Constitution, but there's kind of I think, core values, and then the rest of where we go is a question of trying to make those core values kind of work. So I'm really inclined to say, okay, fine, it's not really spelled out in the Constitution. It wasn't really clear in terms of how people talked about the appointments power, exactly what the role of the Senate could be, so that either Tulis's sort of equal role or Gerhardt's deference, either one would be permissible, and then we can kind of work it out later in terms of how it's actually going to be. But having said that, I think my focus really is kind of on how all of this will work, and in particular with my question of making sure that we're translating collective kinds of choices. And in terms of Tulis's idea with the equal Senate partnership, well, I mean, I had one concern about just how that works practically, because it does seem to me is that the more you empower the Senate, the stronger hand they have to play in this appointments kind of process. And then what could happen is that the Senate could say, well, we're just not going to confirm any nominee, unless, it's the one that we want. And so, we're willing to sort of play this game out as long as it takes, so therefore, President, either cave or you won't get a nominee. And I think maybe, the Anthony Lake thing, it seems to sort of be, I haven't really followed this as carefully as perhaps I should have, but it does seem to me all part of the game that's going on with this Senate, and that, we want our appointees, and we don't really like the fact that you won the election, and so therefore, we're going to try to sort of spring this out. And I guess my view would be that if you eliminate, at least my question is rather, if you lessen the deference, right now there's at least some expectation of deference, and you still have this going on. If you get rid of that, then do you so strengthen the Senate's hand so that you basically end up with the Senate nomination, Senate appointment, and not presidents? But I think my main question is really about, okay, let's say that we have this equal kind of a Senate role. What does that say about who has the power to sort of influence these choices? And in particular, my concern is just with the Senate as a sort of conservative force. And it seems to me that because of the way in which the Senate is selected, and because first each senator has got to get majority vote in their own state, and then once you're in the Senate, you have the party system, so that a majority of these majority senators now they have power. And then you need to get the vote of a majority of the Senate. And I guess Lowy yesterday was talking about the idea that it's even a sort of supermajority of the Senate in some way. But that you need to get a vote of the majority of the Senate in order to really get anything accomplished. And so it seems to me that the consequence of that is that in terms of who the Senate represents, that it ends up being this. I guess one word I'm trying to think of would be sort of not so much a supermajority, but a kind of a submajority, in that there's this. Sort of who actually exercises the power. It's really a small minority of the majority who ends up being able to control Senate policy. And it seems to me that the consequence of that is that you take power away from outsider voices, because you cannot get power in the Senate because of this kind of filter. So at each stage, more and more voices get locked out as this process sort of develops. And so that's really my main concern, particularly when it comes to Supreme Court appointments, because to the extent that at least part of the Supreme Court appointment is about, these sort of institutional value choices. Some of it is, it seems to me, just kind of a policy judgment about, okay, will this justice work out well? I think that's sort of the character and the competence stuff. And even as to, all right, what is the judicial philosophy going to be? Some of that may be a policy issue. Okay, do we think a federalist view it will work better, than a more libertarian view or than a more individual rights view or something like that? But a lot of it, I think, is just this sort of first order. It's not so much that there's a right answer and we have to figure out what the right answer is, so much more so than it's just that we're going to decide. We really favor, federalism values over, let's say, individual rights values because, we think that's part of how we're constituted as a polity or whatever. And so to the extent that you've got those kinds of value choices being made in the appointments process, I'm somebody who wants those to be inclusive, to want a process that's not really this sort of little minority that makes the decision, and the minority of the majority, I guess, but wants to have, much more flow through. And it sort of troubles me that the Senate, and I think for that reason, I mean, that's why the Senate, at least my understanding is, traditionally has been more conservative. And I think, if I'm not mistaken, that that's kind of how it was designed, right, to really be a check on populism. But I'm somebody who wants populism as a way of really, thinking about these value choices. And so for that reason, I don't think it's really accidental that a lot of these courts that were developed during the time at which Tulis says there was much more of a vigorous Senate role really were pretty conservative. I mean, when you're looking at, for example, the Taney Court and then the post-Civil War courts all the way up to the progressives, I mean, if, they were selected in the Senate role, it wouldn't be surprising to me that they're this real kind of conservative kind of force, because again, is it the question where you just have this powerful kind of submajority rather, who's really making these kinds of decisions? And I guess I also had some concern about this question of, what kind of debate are you going to have, even if you get a better debate with this more deference? What kind of debate are you going to have? And I guess it does seem to me that there's this risk, and I think other people have said this as well, but there's this risk that, that politicians generally, at least particularly legislatures, care about the results, care about the outcomes, care about, okay, will there be environmental regulation or not, and so forth. And for that reason, will the debate, and at least also particularly the vote, is that really going to be on these constitutive kinds of concerns, or is it going to be, will this justice make it more or less difficult for me to get my policy through, in the future? And so that's another concern that I had. And in terms of, and so for that reason, I guess that's why I'm sort of troubled by making the Senate more powerful, because I think there's this question as to whether or not you're sort of distorting power away from sort of outsider voices and translating that into this sort of sub-minority kind of thing. And I guess just I want to say one more thing about that, and that is, I guess there is an argument that, well, maybe that's okay, because then, it's kind of majoritarian. But I guess I really think there ought to be representation, not just of majority views, but also of outsider views. And I think this applies not just, to progressives, but also, I think that's was a concern with the Carswell, the whole Nixon confirmation battle there. Because I think there's a fair argument to be made that conservatives felt that they were not really adequately represented on the Supreme Court. And so therefore, there's this question about whether or not you're going to really have these other voices represented. And again, it seems to me that it's very important when you're talking about making these value choices to have representation in that way. I'd just like to briefly kind of wrap up with respect to Michael Gerhardt's point, because, all right, I'm concerned about, are we giving too much power to the Senate? But I think I'm a little bit troubled, with Gerhardt's vision of the presidency, and not so much in the analysis of, what makes the president do a job well or not, and all of the questions about management skills and so forth. All of that I found really fascinating, and I don't really have a problem with it per se, but I think it's the vision thing that kind of bothers me, and that is this idea that the president just gets, that in other words, that when you win the election, what you win is almost this unilateral authority to define a vision, to implement it regardless, and then be evaluated on how well you did that. And I guess for that reason, I'm kind of troubled with the Andrew Jackson kind of model, because if the argument is, Andrew Jackson's view was, I don't really care what people say, this is my vision, which is states' rights, and I'm going to get it through regardless, and so therefore, how good of a president I am is based upon my ability to do that. That bothers me, because again, is there an inclusive process for deciding that? And I think particularly during that time, there was a problem with the polity generally being under-inclusive, and a lot of Andrew Jackson's policies, were anti-Native American, were certainly, in favor of Southern states and slave rights, and pro-slavery and so forth. And so it sort of bothers me that the president gets to do that. Now again, the problem there is that you just knocked everybody out of the polity to begin with, and so then, that's obviously not working. But even once you have everybody kind of included, does the president just just get to do this, to just get to step in and say, this is my vision, and come heck or high water, I'm going to get it through, and I don't really care what people think as long as I can sell it to enough people to get elected the next time around. And so that's my concern, with respect to making sure that you have this flow through so that a broad range of voices, including people who might not be, in this sort of vital center, that everybody's views are reflected in terms of how we make at least these sort of higher level decisions about the direction of the country.
Elena Kagan?
Professor Enton's oblique reference in his introduction to the exercise of presidential power affecting the scheduling of this conference was, I believe, a reference to me. Because I do work in the White House, and I did call up here and ask that the program be changed in order to accommodate my schedule. But I want to make completely clear that this was not an exercise of presidential power. Now, I want to make that clear because if it had been an exercise of presidential power, I'm sure it would have been improper and would have been grounds for a congressional hearing. Deference, Professor Tulis? Now, I was reading these papers on the plane, which is what you do when you work in the White House, is you read the papers on the plane. And I read Professor Gerhardt's paper first. And I thought, oh, well, this is interesting because I can just take Professor Gerhardt's various criteria and I can apply them to Bill Clinton. And then I thought, better not. Because either I get in trouble back there or I look like a hack here. And I thought, no advantage to that. So instead, I'm going to focus on Professor Tulis's paper. And I have 3 points, really, that I want to make, and I'm going to try to be quick because this panel has gone on for a long time and there's another speaker ahead of me. I have 3 points. The first point relates to what I just said, which is that Congress doesn't seem so deferential from where I sit. The second point is that when Congress is deferential today in the appointments process, it's because deference is in Congress's self-interest. And the third point, and this is a related point, is that if there has been a long-term shift in congressional deference toward judicial appointments, and I'm frankly a little bit dubious about that, but if there has been the long-term shift that Professor Tulis describes, it's because of changes affecting that institutional calculus. It's because of differences in the way Congress calculates its own self-interest with regard to appointments matters. Now, let me start with the first point. The first point is, what deference? Where is this deference? It doesn't seem like supine deference, which is, I believe, the phrase that Professor Tulis uses several times from the vantage point of the White House. Now, consider this. It has been 6 months since President Clinton was reelected. In those 6 months, how many judges have been confirmed? 1. But you said 0, but I'm going to say that 1 is as good as 0, because the 1 was confirmed for various sort of personal reasons that had nothing to do with anything. It might just as well be 0. And look, it doesn't look like there are any coming down the pike, very shortly in the future. There are tens and tens of nominations up there. Not one of them is moving. Indeed, all the people who had hearings before the election are being told that they have to have hearings again. They have to go back to where the process started from for them, even though they had gotten halfway through it. Now, last year was not much better. Last year, it was true, was an election year, although when you actually compare the election year to various other election years in the past, it's a really quite striking, dramatic difference in how few judges were nominated. Senator Kyle is up there talking about how really the Senate ought to have some of the appointments power itself. For every 1 the president does, the Senate ought to do 1. And there are terrifically qualified people sitting up there, let's say Professor Fletcher is an example, who aren't going to get through anytime soon. Now, it's quite clear that Bill Clinton will get some judges confirmed. He'll get some judges confirmed this year. He'll get some judges confirmed in the years to come. But there's also no doubt that his choices will be constrained and that his choices already have been dramatically constrained. It's not an accident that President Clinton appointed Judge Breyer, now Justice Breyer, and Judge Ginsburg, now Justice Ginsburg, to the Supreme Court. It's also not an accident that he did not appoint such people as Peter Edelman to the D.C. Circuit. It's not an accident that Walter Dellinger is not sitting on the Fourth Circuit right now. All of these have to do with a set of constraints that Congress has imposed. So Congress has effectively asserted itself. Now, Congress has not done so, I agree with Professor Tulis, or it has not done so often, in the way that was done in the Bork hearing. It hasn't done so in this highly sort of public, principled, articulate way that we went through in the Bork hearings. And I, like Professor Tulis, I loved what happened in the Bork hearings. I wrote a review of Stephen Carter's book recently where I said, no, he has it all wrong. The Bork hearings were great. The Bork hearings were educational. The Bork hearings were the best thing that ever happened to constitutional democracy. So I share that view with Professor Tulis. But I also think that although we haven't had many of those, we've had something that is as effective from the point of view of constraining presidential choice, which is this whole set of informal, less public, less articulate, less principled constraints on the presidential appointment power of judges. Now, the second point is that any deference that has been given to the president in appointments power is politically driven, is reflective of the political and practical constraints that Congress itself faces. I mean, there comes a point where Congress decides that it looks bad by opposing every appointment, or that it's taking too much time to oppose every appointment. Let me give you one clear example. The day that Tony Lake took himself out of the process for CIA director was the day that everybody in the White House knew that Alexis Herman would have no problem. It was a straight trade-off, one for one. You couldn't go after both. And the fact that they had killed Tony Lake meant that they couldn't kill Alexis Herman. There were these political, practical constraints that they were operating under that made the one appointment go through after the other didn't. So to the extent that Congress abdicates, in Professor Tulis's word, it's not because Congress really believes, oh, we shouldn't be exercising this power. It's not because Congress is a bunch of self-denying folks who really think that this ought to be done by the president. It's because Congress recognizes that people are watching, that people don't like conflict these days. It's because Congress may recognize that the time it will take to defeat certain nominees is not worth the candle. It's because Congress reacts to a set of practical and political constraints. Okay, now the third point, and it really follows from the second point, is that if there has been a shift, as Professor Tulis says there has been, from the 19th century to the 20th century in the extent of deference that Congress has shown to presidential appointments, I think that shift probably follows from certain shifts that have occurred in the set of practical and political constraints that Congress itself faces when considering appointments matters. Now, like Professor Barksdale, I have to admit here that I'm not a historian, and I was kind of reading this and thinking, okay, I should turn it over to Professor Flaherty there, or I should turn it over to some other people in the audience. But let me suggest a few things that may have changed if indeed there has been a shift of the kind that Professor Tulis suggests. Professor Tulis implies, and I think this is probably right, that there may be a shift in terms of the public's own attitudes about what kind of congressional role is legitimate and appropriate. Now, if there has been that shift, of course, there's a deeper question, which is what accounts for that shift in public perceptions of Congress's role. And I'm not quite sure what the answer to that question is. But let me suggest two other things that may play into this, aside from sort of public attitudes about the legitimacy of congressional action. The first is simply that the public is watching now. It might not be that the public felt any better about conflict then than they do now. It might just be that people see the conflict and it disgusts them, and it would have disgusted them if they had seen it before. But the fact that they do see it now, whether it's on C-SPAN or whether it's on your news, local news, is a constraint on what Congress can do. Now, secondly, is that Congress is just expected to do more. I mean, that is, that it has other business aside from appointments, and people expect it to do other business aside from appointments. And that suggests to me that Congress might think now more than it did in the past that, look, this is not an effective use of our time. The opportunity costs are higher. And the people react to Congress that way and so reinforce that congressional sense, which is people sort of see Congress not doing what they consider to be the real business of the nation, but instead to be doing this kind of partisan maneuvering. And so that's another constraint. Mostly, though, I think that these kinds of factors have changed the form and not the extent of partisanship in the appointments process. I sort of, in the end, I think I have to step back and say to Professor Tulis, what has changed is not the amount of partisanship, is not the amount of conflict, is not the extent to which Congress and the President go toe-to-toe and check each other in the appointments process. What's changed is the form in which that's all happened, that it has become more covert, that it has become less direct, but that there are still these terribly effective, maybe more effective by virtue of being more covert, but terribly effective constraints on presidential choice in the appointments process. Thank you.
I can't talk for 15 minutes, but I will. At 15 minutes, I'll just stop, so we'll just work with this a little bit. The title of my talk is The Presidency, Senate, Appointment and Separation of Powers, the New Historical Institutionalism and Plate Tectonics. Okay. First of all, I want to thank Dean Gerhardt and the professors at Case Western Reserve Law School for making me feel so welcome, sort of as a continuing visiting scholar here. I want to thank also the Dean and his colleagues for seeing the importance of the cross-fertilization between legal and political science scholarship. We see this in many of the best law schools, and it's really great to see it here as a good law scholar. Now, what I want to do in this paper, or in the discussion really, is talk about the whole field of the way we have looked at the presidency and the way legal scholars look at the presidency. In preparing for today, I looked at Calabresi and Lessig and Sunstein's study of the presidency, and I looked at Calabresi and Rhodes' view, and we see a great fight, originalism versus non-originalism. We see a great fight by very smart people about what the moral basis of this whole look should be about. Do you look at history in the light of the originalists? Do you look at the originalists in light of the originalists? And that's one way of looking at this. Again, internal looking. I'm like Ted Lowy, really. I'm a boundary man. I really believe the real issue in almost all politics and all issues is the nature of boundaries of debates and structures and boundaries of what's in and out. And I'm going to keep asking myself, what is in and out of the study of the debate on presidential politics? The interesting debate, Michael Phipps talks about structural changes that appear to enhance the power of the president. And then he finds that, in fact, these changes don't enhance the power, but reduce the power. Phipps' argument is self-consciously an extension of Theodore Lowy's The Personal President. And he sees presidential political weakness in the president. The primary objective of Phipps is to explore how the source of at least some of our frustration with the office of president is a result of the structure of the position. Again, it's a structural argument, and he's trying to ask the question of, does the form meet the structure, and how does structure affect form? We saw yesterday Lowy's masterful and original keynote address. He asked the question about, he argues originalism can never replace history. In fact, history has given us the party system that Madison didn't like, and the party system has given us this duopoly, this wonderful word that, well, what a word. These developments are a product of history. Therefore, originalism can't be the answer. At the same time, always in the background is the question of the originalist and what is the normative foundation for how we look at these issues. Lowy concludes The parties are not following any intent of the framers. The presidency has simply strengthened in relation to Congress as a coincidental and accidental consequence of winning elections. At the same time, in Lowy is a very strong sense of the Constitution, a strong sense of Federalist tenet, a strong sense of those values. At the same time, those values are not the originalist values as laid down. Also, I think it's important to ask the question about the change from a neo-Wilsonian institution to a Rooseveltian institution to this duopoly, absolute separation of powers. This is the question I have is how we got here. How do you explain it? The other question I have, and it informs all of my thoughts here, is how do you bring the outside into the study of the presidency, not the presidency in the study of the outside? How do you bring the outside into the study of the presidency and not questions of the president and Congress? This completely internal look, in my view, just a completely internal look, can't really get at explanation. It can't really ultimately get at issues of normative concern, I think, that we have. Also, I want to argue that what we may have, and therefore the end of liberalism may be still with us, what we may have is layers of governmental structure in new historical conditions. What that means is that iron triangles are still here. What it means here is divided government is still here. What it means is this sort of absolute separation of powers here. We get these layers, and therefore we don't replace sort of regimes of president and Congress. If that's the case, then it's possible to have a more complex argument about the nature of the problem of stasis and not have to go right to duopoly now. It seems to me the problem is difficult. And it becomes more difficult if you look at the question of the globalization of the economy, where in fact these actors can only act in these different structures in ways that make sense in terms of outside economic forces. In other words, the outside has to be brought in. And therefore, I would argue that we should go back and see these different sort of layers of institutional organizations. Shane and Fisher also fight about originalism and non-originalism, and Shane asks us for sort of a rule of law-ish argument. In other words, a real rule of law, bright line distinctions can't work, but there's a rule of law, it's really a rule of compromise, a rule of agreeing to disagree within a bounded condition. Now, that's still a structured condition from within. Also, Neil Devins does a wonderful paper. In reading the paper, I kept thinking, really, it's the second part of Lowy's paper. Because what the item veto paper, we'll talk about it after this, is really a paper about what duopoly has caused the president to do with regard to item veto and what the item veto happens within a duopoly situation. Now, but my real thoughts for today are Mr. Tulis and Dean Gerhardt. I won't go through Tullis's argument. It's a very subtle, filigreed argument. It's an argument that is very modern, even though he doesn't sound modern. It's an argument that talks in terms of deference, and he loves conflict. This man loves conflict. More conflict is better. From conflict, all things happen that are good. And what he argues is that we've lost the structured constitutional discourse. And he wants to lay on the appointment process the notion of constitutional discourse. It's deliberative democracy, and from that, we would be a better. And therefore, as we said, he said the Bork nomination was fine. He liked the politics of the Bork nomination. Now, let me raise some questions about Tullis's paper. Just in the form of questions, and there's a lot of questions here, but let me raise some. Does the call for constitutional discourse and re-education mean the litmus test by the president and senators are fine? Do we have litmus tests or not? Is that discourse or is it litmus test? What is this discourse? This notion of discourse in the paper is not worked out. It seems to be a general good that appears and it flows in and out of the paper, but what does it mean? What does the notion of the nature of the constitutional regime mean? Now, I'm going to be clear with you. Yesterday, in a very nice talk at Oberlin, Jeff did a very nice job of linking it into his view of the separation of powers, which he brought to you today. It seems to me there must be a statement about this question of discourse in light of the role of the court, the president, and the legislature in the scheme with regard to the place in that larger picture. Without that, it just becomes a general more politics is better than less politics argument. And I think he means more than that. Also, I think it's important to ask the question, we need this idea of separation of powers and the role of each branches. And when we get that, then you're going to have a problem. And here's the problem that as I see it. At Oberlin Thursday, he said very clearly the role of the court is to be counter-majoritarian and to protect rights. All right. In this paper, the argument is more constitutional discourse in the appointment of justices. Here's the problem: does that discourse undermine the notion of the court as counter-majoritarian and the court as as protecting rights? What I'm trying to suggest here is open debate always good about that? It seems to me that, and here we get into sort of a putting together the duopoly notion, it may be that when you get to that position, the duopoly situation forces muteness and forces justices that you would not want. So that relationship bothers me, because if in fact the role of the court is to be counter-majoritarian, if the role of the court is to protect rights and sort of apply the law, whatever that means, then in fact robust debate and open debate about constitutional discourse may in fact have the opposite result that you want for the role of the court in separation of power system. I think there's a conflict there. Also, one question I kept asking is, what role in does the confirmation process have relative to the amending process, relative to the interpretation process? It would be very good to get into a notion of the role of each of these processes in developing constitutional discourse, because it would give a context for the role of confirmation in your overall notion of political change that you have in your thing. I think that would help very much in what you're doing. So what we're really talking about is standards of evaluation, regime needs. But notice, it's still an internal-looking argument. It's still an argument from within. It's still an argument where the outside is not there. In other words, constitutional discourse is good for itself, and let's just have more of it. Now, Michael Gerhardt's paper. What Gerhardt does, in a very subtle way, and I'm really responding not just to this paper, but to other stuff he's written to get a bigger sense of it, but what Gerhardt has done really is try to ask the question, what are our standards of evaluation for the president? And he talked about some of those standards of evaluation. Some of it is good management, some of it is being a good politician, but then he starts eking out into a structural argument. It sort of appears, but he's afraid to really push it far because, we got to keep pushing. This is the argument that he seems to be making. The type of actions that a president can make, are directly related to the place that his or her presidency is in, and the place that the regime is in at a given time. What he's done a very subtle job in doing is trying to talk about the standard of evaluation has to be put in the context. What is not done, and that the next step is to ask, what are the structural conditions of those different contexts, and what are the outside sources that produce those structural conditions, whether it be duopoly in Lowy's terms or in your terms, it's not the number of, it's what you bite off, and if you bite off a little bit, you're not a great president. If you bite off a lot, you're a great president. So the question is getting out the outside in, and I think that would really help. It would force us to ask important questions. So I am concerned about strong presidents and Senate and all these questions that we've been talking about, but it seems to me that these are put in the context of the outside in. Now, let me talk a little bit about, so his paper is still at the level of the individual president. It's at the level of the president in historical context. And I think that we have to sort of invert it or get more subtle inside-out notions. Now, so one of the questions I'm asking is, to what degree do presidents shape the choices, or do structural conditions shape the choices of the president? And what I keep thinking about in thinking about both of these papers is the notion of identity politics today. The notion of identity politics today. It may be that duopoly is a product of a great fear by both the Republicans and the Democrats in terms of how to deal with identity politics and not interest group politics, and fear of, in the Democratic Party, a great fear of some of their identity groups going wild. In the Republican Party, hell with all of them, just keep our little group together. In other words, what I think we have to get into is we have to get into what are the causative agents of duopoly or changes in structural conditions. And those are not necessarily inherent in the institutions themselves. An underlying theme of all the papers is that presidents and internal institutions cause outcomes, and therefore there's a false sense of individual or institutional agency here. And I'm asking us to invert it, the other way around. Now, why do I talk about plate tectonics here? Thinking of Stephen Skoronek's, not his book on the presidency, but his later stuff on the new institutional historicism, new historical institutionalism, excuse me. Let me go through some of the questions they deal with, and this is the type of thing I think the direction in appointment politics or presidential power, institutional politics have to go. We need to link institutions to enduring socioeconomic and political structures that mold behavior in distinctive ways. We have to develop middle-range theory that confronts issues of historical contingency and path dependency. That also means how the outside structures the relationship of President and Congress. We have to view institutions in dynamic terms in relation to the outside world. Systemic thinking about the relationship of different layers of government. Here's what it is. If you have the legislature, the presidency, and the courts, the importance of each of those big institutions changes historically over time. The important question for me is, why does that change occur? I got it. And how does the president and how do the different actors react to that change? And it seems to me that picks up some of the internal evidence in your paper where you actually do that. The question is building it out and, and putting it back in again in structural terms. Also, I think it's important to realize that I think unless constitutional scholarship and constitutional law and theory, and I'm doing this with regard to a project I'm doing on equal protection with social facts, unless we can bring the outside into the study and not just be sort of an island amongst ourselves in which we talk to each other of people who agree on narrowing the rules of the game, unless we do that, two things I think will happen. One, it'll be irrelevant relative to the question of really explaining the nature of society and law in our society. Number two, if you are interested in social change, you're not going to develop the theory that in fact can be the normative base for that change. All right? And so, because I actually think constitutional theory and what we all do actually has an effect on change to a very complex relationship of the interpretive community back to the court. So what I'm suggesting here is I think we have to sort of put wheels or put a motor on the study of the president and courts, and make it living. Okay, but not so living that there aren't normative values in there, not so living that institutional factors don't have, but living in terms of understanding that the boundaries and the nature of the boundaries are moving categories. And by just picking points out in history, you don't give it that moving quality, although I think in the future we might just do that. Thank you.
To give both Jeff Tulis and Mike Gerhardt a chance to respond, and then I hope we'll have a couple minutes for questions, but we are running a little behind schedule and we have some constraints on the next session, so we can't keep the discussion going too long here, but let's at least get a...
Let me just make 3 points, one to Dean Gerhardt and one to Ms. Barksdale and one to Elena Kagan. My paper is very different than Gerhardt's. Gerhardt's paper is a species of institutional partisanship. It is an argument from the point of view of the president, and it asks, how could the president be more successful at getting what he wants, albeit in a long-term rather than a short-term sense? My effort, along with others like Skowronek to some extent and Lowy and others, is an effort in political diagnosis from a systemic perspective. And despite what Ted has thought in the past about me, I actually don't love the president all the time. And this is one case, and this one case, one instance of that. So the question becomes, how should the system be constructed so that it can be a fruitful and productive political system and avoid the kinds of pathologies that Ted pointed out yesterday. Now, with respect to the 2 of the commentators, I won't be able to say anything about Ron's. I'm not sure how to get my hands around Ron's remarks. But with respect to Yvette, just a couple points. Yvette's concern seems to be a worry that one particular value that might be important in the selection of justices, that is a more inclusive arrangement in which the views of excluded voices are brought into the process, might not be advanced by, by more aggressive senatorial participation. I don't see how, I mean, I can see the argument that that value won't be maybe maximized to the extent that she would like, but I fail to see how it could be better under present circumstances, how that concern would be better leaving things to the President alone. And then the only second point that one wants to make is this is never about one value. It's about a constellation of values, and in fact it's about the contestability of that constellation of values, and a process in which the Senate and the President were engaged in conflict would be partly about the extent to which the appointment should reflect more inclusive voices along with other concerns. I have actually, I'll have to save a lot to talk to Elena later. I agree with a lot of what she has to say. In particular, it is true that there is a kind of paradox here that as the Senate, as the confirmation process for senators has become more public, the pathology that I describe has actually become more intense, so that in the 19th century, you could say the debates were public, and in fact there was a great deal of popular attention to them. But there were no hearings, there were no interrogations of the individual person. The views were interrogated, but in fact often executive session. So she really is onto something about the connection, ironic connection between the publicity of these events and their non-event character in the end. But what I found most remarkable in all her remarks, and I can't cover them all, there are a number of good things that I think she said, but most remarkable to me was the observation that what has happened is that politics has changed form. It's not the extent of partisanship or conflict, but the form in which it occurs that has changed. Precisely. And it is remarkable to me that we would have lawyers unconcerned with the forms of politics. That is, in fact, where political responsibility lies, in the proper formation of politics. So I can't get into all the details, but I'll just conclude by saying one thing. It extends from yesterday's remarks by Ted Lowy. Ted pointed out that there still is a lot of partisan politics. There's still a lot of partisan politics. It's just chicken shit politics. It's about it's just about unimportant, marginal concerns to the life of the republic. And so when Professor Kagan says, "Geez, you know, I just got off the plane and I'm still reeling from all the lack of deference up there," it's chicken shit politics. It's not politics about the important questions. It's not about Supreme Court appointments. It's not about war powers. It's not about the deference to the court over the custody of the president's own powers and responsibilities. It's not about the Senate and the Congress as a whole repeatedly writing into legislation now that maybe they don't know what the constitutional thing is, so they'll leave it up to the court to turn down some some clause that they've already specified might actually be suspect, because they can't figure out whether it's a correct constitutional position in the first place. This is chicken shit politics. It may be conflict, but not on the order of 19th century conflict. Thanks.
I'm already in motion. I won't say I'll be brief, but I will try to be brief. I just want to make obviously some responses to some of the points made. Let me begin with Yvette. I think probably the best response I can give is to simply clarify some of the things I've tried to suggest. Let me begin by saying I'm not arguing for presidential dominance, and instead, in fact, I've written a great deal over the years and have sometimes consulted with senators about their participation in the confirmation process. I have always thought a vigorous participation by the Senate in the appointments process is a good thing. And in fact, I think it's a good thing for the reasons that Jeffrey points out. I think that it is part of the checks and balances of our Constitution in motion, in operation. And so therefore, what I argue for, if anything, is something very similar, which is to see these institutions, in fact, engage and not simply either sit back or become distracted by, I think, less than noble ideals or issues. And so I'm not arguing for anything like an imperial presidency, nor am I arguing for deference to the president, nor am I arguing for Senate deference. I think that there is an engagement that I think is a good thing. I think it's contemplated by the Constitution, and that's what motivates me in part to talk about the presidency. My concern about the presidency is very simple. It simply gets left out of most discussions about the appointments process. It's really just that simple. If you look at how most people write about the appointments process, it begins with the moment of a nomination having been made and the controversy that's engendered by the nomination in the Senate. Well, that's like starting in the middle of a story. And my point is to talk about the fact that there's another story. Now, Ron is absolutely right. I need to talk about a much broader framework within which to try and construct that story. But my concern is not to lose sight of the broader, bigger, more important story that includes two huge institutions that I think oftentimes come into conflict over nominations, sometimes for petty reasons, clearly for petty reasons, but sometimes for reasons that I think are not so petty. I think the difficulty at the moment in part is that there's so many issues that they're trying to deal with that sometimes they make trade-offs, as Elena, I think, was suggesting, and sometimes those trade-offs result in better discussions, more noble discussions, more literate discussions than others. Let me just sort of say briefly, I agree with absolutely everything Elena says, particularly about my paper. Which then brings me to the other two. And again, as I've just said, I agree with what Ron says. I think he's absolutely right. I think that there is a broader context in which one needs to place the dynamics of the interaction between the President and the Senate on appointments matters, and it's a wonderful challenge, and I will try to accept it. I hope live long enough to surmount it. And with respect to Jeffrey's last couple comments, I think in large part we actually are in agreement. I think that my aim is not so much to sort of suggest that we should look at everything from the perspective of the presidency. It may have been, it certainly requires further clarification on my part if I've suggested that ought to be the point of view. Instead, as I've just said, my argument is simply that there is a broader framework within which these contests occur, and I think we need to understand that framework. And that brings me to a close.
Yeah, just a minute. Yeah, I would like to respond just very briefly to Jeffrey's point. And that is, number one, with respect to the idea that sort of including outsider voices is just one value, the constellation of values we have to consider. But I guess my view would be it's like the value because it has to do with the very definition of freedom within a democratic society. And that is that everyone gets to have input. And it's not, and I'm not just talking about sort of historically excluded voices like minority groups and women and so forth. But in general, people who get left out of majoritarian politics, isn't there a point at which you have kind of a right to participate in a process, at least for these sort of broad-scale kinds of institutional direction kinds of issues? That's number one. And second, I guess I didn't really lay out, which I probably should have, my view as to why the president's better. But it seems to me that because of the president's constituency, that the president is going to be more open to the fringe. I mean, the president always, I think, has to start from someplace in the middle and work out to the fringe. And the president doesn't really want to lose eggs in the same way that I think the Senate can more safely, because it's only one state, as long as we get the majority of the state, that's sort of it. And so because the president has to get this sort of global country kind of support, there's a point at which the constituency starts at the middle and goes to the end, and there are people left out of the president's constituency. And I think that's where the Senate comes in. I would just prefer to see, it seems to me, the Senate constrained in some way so that they don't end up having too much power. So that's just my
Jonathan is going to be nice enough to give me a chance to make two really...
He's the dean after all.
That's right, so you get your office back. Thank you. Just two brief comments. Let me pick up on something that Yvette just said. I think that I'm not, given the way the presidency operates, and I don't pretend to be a great expert on it, I think that there are problems of access to the presidency in terms of the fact that it's a somewhat isolated institution, and I don't know to what extent the presidency is any better than the Senate in terms of digesting and getting disparate views. You could make an argument, I suspect, that it's not as good, but I think that that's an empirical question and one that needs to be asked and that's supposed to answer. The second thing is I just want to make a quick clarification as well about Jackson. We were talking about Jackson. I think my discussion about Jackson, if anything, was meant to sort of confirm or express agreement with Jeffrey's point. I think the thing about the Jacksonian contest with the Senate over nominations is they were about big issues. They were about really big issues. Personalities clearly did play a part. I mean, obviously, Jackson and Webster and Calhoun and these people, they had pretty vibrant personalities and personal disputes, but I think the critical thing is when they were talking about the fate of the National Bank and they're talking about the relationship between Congress and the President and between the President and the states, those are big issues. They don't get any bigger really than that. And that characterized the nature of the discussion. All I meant to, and one of the things I meant to suggest when talking about Jackson is the fact that I think that was a moment in time, a moment in history in which there was great engagement between the President and the Senate, and therefore it reflects a lot about presidential performance and Senate performance. The very last thing I'm going to say is a comment about Ron's opening comment. And Ron, all I will say is that in your comment about sort of seeing, I think it's enough to say that you see great discussions like this at great law school.
Now, if there are maybe one or two questions, let's see if we can do that. Yes, sir.
Okay, this is a question for Dr. Tulis. In your analysis, have you taken into consideration the fact that the Senate changed dramatically in about 1918 or so when it became an elected institution rather than an appointed institution? Would that have had any impact on the fact that there was more debate in the 19th century than there is in the 20th century?
I don't think it has. There was some up until, I mean, it really doesn't, I refer to the 19th century as a kind of locution, but it spills over into the 20th century, and it's really since the 30s that since the late 20s, that the real difference is set in. I think that some of the things that Elena mentioned are more decisive, which were the publicity of these hearings, the television cameras present and so forth, which is a little bit of a problem for my argument, because I think one of the virtues of a politicized process is public education. One of the big virtues of it is public education. And in the 19th century, we had a reading, well, not a reading, but a listening public in which those that read talked with others who were much more politically literate than our own citizenry, even, which is more literally literate, but is not as politically literate. And there are a lot of ironies built into the move from written communications to visible and oral communications that bear upon your question.
Mike Fitz?
You may just have answered my question, but first let me say I haven't read your paper. I apologize. On the other hand, that's never stopped me before from asking a question. I take it that you have two purposes. One is to reestablish an equal partnership between the Senate and the presidency and appointments, and also to recreate this moral dialogue. But my question is, in a sense, are those two goals inconsistent with one another? That is, it may have been true in this more homogeneous community in the past that the moral dialogue could develop over appointments because of the sort of hidden relationships between the two branches. But today, where it's going to be on C-SPAN and broadcast around the world, is it more likely that what's going to develop is the exact opposite, sort of stealth nominees or nominees who, in a sense, are going to hide from that?
Well, the problem with the stealth nominee is a problem that the Senate has allowed to happen. That's my whole point. The only reason that you can have a stealth nominee is if the Senate accedes to the proposition, for example, that having written nothing on constitutional matters, is in fact a qualification for being on the Supreme Court. But in fact, if they took the position that itself would be disqualifying, which they could possibly do, they would change the structure of incentives that the president has to nominate people. And on the other hand, in the 19th century, things were not as sort of cordial among the aristocrats as your remark might suggest. These were pretty brutal, bloody battles sometimes. So they weren't necessarily polite, even though the political education was more incisive in some ways.
Okay, I think we're going to have to cut at this point. We have, Ted Lilly has an early flight this afternoon. He's on the next panel, so let's reconvene at 11:45, which is 10 minutes, and we'll